From day list for final dispute item 1, second appeal 118 of 2010.
Order dated 9/9/2025. My two substantial questions of law is being from Para Seva. Number one, whether the learned first appellate court was justified.
You read the order, please. Order पढ़िए.
Written
Order
order.
पढ़िए. हाँ.
This appeal has been filed against the judgment and decree dated 10/6/2010, duly signed on 19/6/2010, passed by District Judge Durga, whereby the title petition appeal number 5 of 2008 filed by defendant has been dismissed and the judgment and decree dated 2012/2006, duly signed on 6/1/2007, passed by the learned subject one Durga and title petition suit number 5 of 2003 has been confirmed. The partition suit was filed in connection with self-acquired property of defendant number 1. Some of the defendants, including defendant number 1, filed their statement, but they ultimately did not participate in suit proceedings. The learned trial court decreed the suit and granted suit 5/12 share to the plaintiff. The daughter of the defendant number 1 was not a party in the suit. Filed the first appeal along with the defendant number 13. The first appeal was filed alleging non-joinder of necessary party by the daughter of defendant number 1 and on account of improper service of notice with respect to defendant number 13 and also on the merits of the appeal challenging misconstruction, non-consideration of certain documentary evidence placed on record before the trial court. The learned first appellate court dismissed the appeal by holding that the daughter of defendant number 1 was claiming that suit property was the self-acquired property of defendant number 1, but the defendant number 1 did not file any appeal, and with respect to co-appellant defendant number 13, it was observed that the notice was duly served, but he chose not to participate in the trial. It has been submitted by the learned counsel for the appellants that the suit was declared without entering into the core of dispute as to whether there was any weakness of fund of the joint family with respect to purchase of suit property involved in this suit. In this case, it has been submitted that the daughter of defendant number 1 was a necessary party in the proceeding. The defendant number 1 had 10 sons and 1 daughter, and in case the suit property was self-acquired property of defendant number 1, she would have got share of 1/11th suit property upon death of defendant number 1, and otherwise she would be entitled to only 1/11th of 5/12th of the property. Learned counsel submits that property having been declared as joint family property by the trial court and was subjected to partition, the daughter of defendant number 1 was certainly a necessary party. The learned counsel for the respondent number 1 has appeared and assisted the court as to why the records have already been called for from the concerned court. He has submitted that the defendants did not contest the suit and appear there was partition. He has assisted this court in going through the improved judgment and has submitted that on the basis of the appreciations of material on record, the learned trial court come to finding that the suit property was purchased from joint family fund. The learned counsel has also submitted that the appeal was filed on limited point of non-joinder of necessary party and with regard to non-service of notice upon defendant number 13, and therefore only those points were primarily considered by the learned first appellate court. He has also submitted that if the suit property was self-acquired of defendant number 1, then there is no question of any share of daughter of defendant number 1 during the lifetime of defendant number 1 who did not file any appeal from the trial court's judgment. He has further submitted that the daughter of defendant number 1, as per claim, would be best be entitled for 1/11th of 5/12th of the property if it is taken as joint family property, but would have no right if it is taken as self-acquired property of defendant number 1. The learned counsel for the respondent number 1 has also submitted that the defendant number 1 to file written statement, but did not disclose the name of his daughter in written statement or at any stage. The learned counsel has submitted that the right of all the legal heirs and successors of defendant number 1 was duly represented by defendant number 1 himself, and his children are claiming under defendant number 1, and therefore the improved judgment does not call for any interference. He has submitted that no substantial question of law arise for consideration in this case, and therefore this will be dismissed. It is not in dispute that the defendant number 1 and also his sons were made party in the partisanship, but the daughter of defendant number 1 was not made party. Now, the substantial question. This appeal will be heard on the following substantial question of law: whether the learned first appellate court was justified in dismissing the appeal filed by the daughter of the defendant number 1 Musa Devi, who was not a party in the suit seeking partition of the suit property. Second, whether the learned first appellate court has erred in law in not deciding the appeal on merits on the ground that court appellate defendant number 13 was duly served and duly served the summons, and the trial was expected against him, although the defendant number 13 had challenged the judgment of merits as well as alleged illegality in the matter of service of summons, and thereby the learned trial court has failed to follow the provision of section 96 of Code of Civil Procedure while deciding the first appeal. Well, these are the two questions. Well, what has happened in this case? The appellate court has only dealt with the appeal only on the ground whether these persons are capable of filing an appeal or not, and therefore dismiss the. Therefore, I am reading
By
the finding.
holding that they are not competent.
They said they are not competent. The finding of the appellate court. Page 4 onwards. The appellate court has formulated 3 points for determination. Internal page 4 of the appellate court.
Yes.
Whether the appellates number 2 were necessary party to the suit, whether the appellates are really aggrieved with the improved judgment and degree, whether the service of summons against the appellant number 1 was sufficient and proper. All the above 3 points are taken together for adjudication. We read the case account along with improved judgment and degree in the light of contentions raised on behalf of both sides. It appears that the original suit was instituted by one Bhupeshwar against 16 defendants. Defendant number 1 is the own daughter of plaintiff, and defendant number 2 to 11 are sons of defendant number 1, who were arraigned as defendant first party, and other defendants are arraigned as second party. Appellant number 1 is original defendant number 13. Upon service of summons, defendant number 1 to 8, 10, and 11 appeared and filed their joint written statement on 4/6/2003. It further transpires that service of summons against appellant number 1, defendant number 13 was presumed to be served by the order dated 2/5/2025.
दो बार क्यों लिखा है? Appeal number 1 / defendant number 13, right?
Appellant number 1 here
Was presumed to be served. Yes.
was presumed to be served by the order dated 2/5/2025 with the information that registered notice issued against this defendant was not returned after expiry of 30 days. It is also here pertinent to mention the admitted fact of the appellant in memo of appeal. It is submitted that the present appellant that the suit property was exclusively purchased property of defendant number 1, which was subsequently sold in favor of defendant number 2 to 11, respondent number 3 to 12, through sale deed dated 9/1/1968, and these respondents are in exclusive possession of the same. This piece of evidence is in very clear terms and appears to be voluntary. From this fact, it is crystal clear that neither appellant number 1 nor appellant number 2 have any right, title, interest, or share in the suit act. Here, madam, it has come in the WS, but this fact has never been proved in the trial. Now, if it is admitted that that is self-acquired property, then also the finding of the trial court is required to be satisfied. Have any right, title, interest, or share in the suit land. As such, whatever the degree may be passed in the suit, but that appellant cannot be said to be a aggrieved person. Moreover, they are not necessary party to the suit. In absence of appellant number 2 as a party, the merits of judgment cannot be said to be affected. The improved judgment and degree is not prejudicial to the interest of present appellants. As such, in my consideration, present appellant has no right to prefer this appeal. Appellant number 1 has raised no ground in the memo of appeal that summons was never served upon him. Rather, he has submitted that he thought that the notice was given in title suit number 379, which was already disposed of by order dated 26/4/2002. This fact also clearly indicates that after receiving summons, she did not care of it to approach the court and know about the real matters. From the result of improved judgment and decree, I further find that out of 12 main defendants of this case, only defendant number 9, Padmansa, was not served with notice, no service of notice was presumed to be valid, and no ex parte order passed against him, but he has not challenged the improved judgment and decree. This defendant number 1 to 8 and 9 to 12 have filed their written statements, but they did not produce any or documentary evidence. They have also not preferred any appeal against the improved judgment and decree. It appears that the contesting defendant number 1 to 12 have set up the present appellant in order to protect their own interest from the consequences of improved decree. I have also gone through the aforesaid citations that were upon the appellant, and on careful study of it, I find the aforesaid ruling are not applicable in the particular facts and circumstances of the present case. Thus, all the above points, 3 points are decided with the appellant. So the appellate court has not at all considered the veracity of trial court judgment. And so far as trial court judgment is concerned, the trial court has only quoted the submissions of the counsel for the plaintiff, and thereafter come to decided the suit in their favor by citing the Mullah Hindu law of presumption and non-presumption, but has never come to a specific finding that there was nucleus which was capable for purchasing a property, and therefore only the owners will shift to the private defendant. But that finding is not there.
And so far as doctor is concerned, the plaint was filed for a declaration, plaint was for partition.
Yeah.
So since the plaint was for partition, the doctor ought to have been made party. Ought to have been made party. If you are seeking partition and seeking a declaration that this is a joint family property, then the daughter of the defendant number 1 ought to have been made party. This part, according to you, is not correct.
Not there. And my lord, even in appeal, the appellate court says that as the father has transferred.
Who is appealing for the daughter?
I am appealing. In appeal, the appellate court says that the father has sold the entire property in favor of son, and therefore nothing has been sold in favor of the daughter. Therefore, daughter was having no right, and she could not be. She is not an aggrieved party.
Father had sold the property.
No.
In this case,
जो single person, जो defendant number 1, in whose name the property has been purchased, subsequently he sold the property in the name of his all 10 sons, but not in favor of daughter. But if the daughter would have been made party in the suit, she could have also challenged this said it against all these persons. Similarly, these are the judgments. Now I am relying upon 2 judgments.
the property in the suit was only this property, or there were other properties?
They have also filed. In trial court it has come. There was a partition in between the parties. That was a registered partition in between the parties, in which all other properties were decided. उसमें आगे खाली एक लाइन मेंशन रह गया था कि कुछ बचा होगा तो बाद में बांट लेंगे, तो उसी में कहे कि बस यही बचा हुआ है, अब इसको बांटने के लिए हम पार्टीशन शुरू कर. There was earlier partition was there, and that was registered partition that was executed by the plaintiff itself. कि 1980 में ही 2 गांव में हमारी प्रॉपर्टी थी, सारा प्रॉपर्टी आपस में बांट दी, तो वो लास्ट में एक लाइन सिर्फ लिखा हुआ था कि बचा होगा बाद में बांट लेंगे. And only that ground they say कि this is the only property which was left out, and therefore the partition.
And therefore they claim that it has been purchased from joint family fund.
Yeah.
And therefore it's a joint family property. And defendant number 1 was contesting this one.
Yes. What has happened in this case, this suit was filed in revenue court initially. They were noticed, they appeared, they filed their written statement. Subsequently, that suit was dropped, or the same was sent to the civil court. But these persons, after getting the notice, thought this notice is coming in that one, and therefore they have not. This is the case, and the suit proceeded ex parte. So there was WS, but subsequently they have not contested this one.
What do you say?
हमारे 2 points पर है. एक की पहला कहते हैं कि डिफेक्ट डॉटर जो है वो नेसेसरी पार्टी है कि नहीं. Now we have claimed daughter is claiming her right through her father. Her father is already on defendant number 1. whatever share she'll get through her father. One father is there, she is not necessary part. Because अगर 5/12 शेयर उनको मिला है तो उसका 1/5/12 का 1/11 शेयर फादर से इनहेरिट करेगी. Now the second question arose कि why son have been made party? अगर जब डॉक्टर का रिक्वायरमेंट नहीं है तो then why son have been made party? Now their claim कि वो जो 68 में वो 10 अपना प्रॉपर्टी जो जिसको सेल्फ एक्वायर्ड क्लेम कर सोल्ड प्रॉपर्टी, they have sold to those 10 sons. So in order to show that they have sold these 10 sons property to 10 sons and the right have devolved in them, that's why they have been made party. One
सेल कब हुआ?
sale 1968
का परचेज हुआ, प्रॉपर्टी का
purchase हुआ, that was in 1950. The 68 में हम उन लोगों को बेच दिया गया.
9/1/1968 को सेल हुआ.
9/1/1960 वो 68 में वो सेल किए हैं अपने
डिफेंडेंट नंबर 1 सोल्ड टू डिफेंडेंट नंबर
2 to 11 1968 में सेल कर दिए. में खरीदे. विक्रय पत्र संख्या 576 डेट ईयर 1958.
58 खरीदा 68 में बेच दिया.
68 में बेच दिया.
कोई प्रेयर था कैंसिलेशन ऑफ सेल?
There was no prayer for cancellation of sale deed, saying that it is nullified. Partition हम लोग मांगे. That's why they have been made party. Other co-heirs have been made also made party. And 5/12 was given. Now,
otherwise there was no need to make them party.
Otherwise there was no need to
no need to make the even sons party.
Sons party. अगर उनको बेचा नहीं जाता तो sons को party नहीं बनाते. Because whatever.
If it were an ancestral property.
जी.
तो बेटा और बेटी दोनों को पार्टी बनाना होता कि नहीं बनाना?
अगर फादर जिंदा है, फादर तक डिवॉल्व कर रहा है और फादर अपने बेटों के बीच पार्टीशन कर दे, अकॉर्डिंग टू माय नॉलेज दैट इज नॉट रिक्वायर्ड, बिकॉज अल्टीमेटली एक ब्रदर्स के बीच में पार्टीशन है. आई हैव फाइल्ड पार्टीशन सूट अगेंस्ट माय ब्रदर्स. उनको मिल जाएगा जो शेयर 5/12 शेयर से. नाउ ये 5/12 शेयर
अंडर द Hindu law, the child acquires a right over the property by birth. ठीक है. तो जब भी जीनोलॉजी आता है, जीनोलॉजी में सारे माइनर बच्चों को भी पार्टी बनाया जाता है थ्रू देयर गार्जियन, जो भी उसके गार्जियन. ऐसा नहीं होता है कि अगर फैमिली में 3 जनरेशंस है ऑलरेडी तो सिर्फ फर्स्ट जनरेशन को पार्टी.
They have not even in their WS, जो फादर ने और बेटों ने WS डाला है, they have not stated, they have not taken this plea that कि मेरी एक डॉटर है जिसका नाम ये है.
Might not have taken up.
So now once they have lost, now they did not challenge it. Now बेटी आती है कहते हुए कि I was the necessary party, and defendant number 13 आते हैं कि मेरे को नोटिस सर्व नहीं हुआ.
डिफेंडेंट नंबर 13 का तो भूल गए.
तो 13 का प्रिजम्पशन को लेके चलते हैं माय लॉर्ड.
डिफेंडेंट नंबर 13 ने नोटिस नहीं मिला इस पे तो कंटेस्ट किया. मेरिट पे भी कंटेस्ट किया कि नहीं?
नहीं, वो तो रीड कर देखिए मेरिट पर कि उन्होंने कहा कि मुझे लगा कि 1997 का सूट था उसका नोटिस मिला है.
कि अपार्ट फ्रॉम दिस टेक्निकल प्ली दैट ही वाज नॉट सर्व्ड विद द नोटिस एंड अपार्ट फ्रॉम द प्ली दैट ही डिड नॉट पार्टिसिपेट, डिड ही take any plea on merits of the case?
No, man. Even in the appeal of memo last में ornamental है कि उसको जो है documents consider नहीं किया.
So ornamental थोड़ी होता है.
नहीं, my lord, वो she has only said है कि document which was brought on record. Now the case is कि if there was only examination in chief, none of the party, none of the defendant appeared to cross. There was certain document. Now the second part of that document has not been created. There are exhibit 3 and exhibit 6 which says about the Panchanama. जिस पंचनामा में लोगों ने कहा है कि they have accepted कि this is joint family property.
You see, this is on merits. The appellate court has not decided the case.
That's why the appellate court has not decided on merit.
Yes.
Now because not only my lord has promoted 2 questions. नंबर वन, if duly served or not. नॉट सर्विस के लिए उन्होंने लिया है कि उन्होंने प्रिज्यूम किया कि एसएआर कोर्ट से हमको मिला हुआ है, इसलिए हम अपीयर नहीं किए. दैट प्रिजम्पशन कैन नॉट मेक द सर्विस इनवैलिड. दे हैड वेरी मच.
दो पॉइंट है, whether the learned first appellate court was justified in dismissing the appeal filed by the daughter of defendant number 1.
नहीं, उस सेकंड, हाँ, उसलिए उस पर
उसके बाद whether the learned first appellate court has erred in not deciding the appeal on merits on the ground that co-appellant defendant number 13 was duly served and the trial was ex parte against him, although defendant number 13 had challenged the judgment on merits, as well as, you see, the fact that he did not appear in spite of service of notice is intact, क्योंकि उस पर substantial question of law नहीं बना. मुद्दा ये है, the point is that okay, I was not served, I have taken this as one of the grounds, but there are other grounds on merits. So let us see the memo of appeal.
Memo.
Did they contest the suit on merits as well, or they did not?
Memo of appeal, my lord, they have formulated.
कहाँ है इनका memo?
para 4 में दो ग्राउंड है memo of appeal. But the para 4 में ये लोग लिखे हैं, for that the said title suit number 5 of 2003 was decided ex parte and without contest, and the same was not decided on merits without proper service of service.
वो तो छोड़ दीजिए, तो point ही नहीं है.
हाँ?
This point is not available to you. That is not within the substantial question.
मेरा यह है, ये दूसरा है. For that the genealogical table mentioned in para 2 of the plaintiff title partition suit number 4 is not correct because the appellant number 2, which Usha Devi, wife of Bhola Bhagat and daughter of Dhaneshwar Shah, has not been shown implicated in plaintiff intentionally and was omitted, and she was not made party in said title partition suit number 4, and as such the suit is bad for non-gender of necessary party. This is it. और apart from that,
आपने तो written statement फाइल ही नहीं किया.
हम पार्टी ही नहीं थे तो हम कहाँ फाइल करें?
नहीं, डॉक्टर का नहीं बोल रहे.
हाँ.
आई एम टॉकिंग अबाउट डिफेंडेंट नंबर 13.
नहीं 13 का.
13 का जो
उस दिन क्या है, हमारा सारा आर्गुमेंट डॉक्टर पे था.
हाँ, तो डिफेंडेंट नंबर 13 से रिलेटेड जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए हैं हम लोग, तो उसने तो मेरिट पर चैलेंज ही नहीं किया.
मेरे को बस वो उतना ही है जो जहाँ पर पैरा 4 में जो बोल रहा है,
ये जो अपील मेमो का पैराग्राफ 2 का 5 में इन्होंने लिखते हैं, पैराग्राफ 4, for that the said title suit was decided ex parte without contest, and there that was not decided on merit without proper service of summons. That is on the proper service of summons. Now for that, learned lower court did not appreciate the document of property brought on record filed on 25/5/2005, that is the registered partition deed number 2437 dated 9/6/1980. This is exhibited. This has been considered.
Just a moment. This has been considered. Whether this has been properly considered or not is the matter on merits.
yes.
Merits, my lord, they have stated only कि document has not been considered, and apart from that दो चीज लेकर के आए थे कि सर्विस ऑफ नोटिस के लिए लेके आए थे डॉक्टर के पैकेट के. Now they have not contested. They have not, just like in the memo of appeal they have stated they have contesting on the both the two grounds. Now in the submission they are saying, the appellant saying कि मेरा सारा आर्गुमेंट जो है वो डॉक्टर के लिए. Just now in this case, in the second appeal also.
नहीं होता second appeal. देखिए उस तरह से
और perversity of the
किसी भी एडवोकेट का कोई स्टेटमेंट पकड़ के हम उनके अगेंस्ट में नहीं डिसाइड कर सकते. We have to, you see, the best part in all these civil proceedings is कि हम लोग को रिकॉर्ड से ही चलना होता है. कभी-कभी स्लिप ऑफ वर्ड हो जाता है. ये होता है, it is very natural. क्योंकि प्राइमरीली जब सब्सटेंशियल क्वेश्चन ऑफ लॉ बना था तो यही हुआ था. ठीक है, तो जो सेकंड सब्सटेंशियल क्वेश्चन ऑफ लॉ है उसमें हम लोग को सिर्फ इतना ही कंसर्न है कि अगर मान लीजिए मेमो ऑफ अपील में कोई मेरिट में कंटेस्ट ही नहीं था तब तो कहानी खत्म है. ठीक है, यू फाइल्ड अ मेमो ऑफ अपील बट देयर वाज नो contest on merits. You only wanted कि सर्विस नहीं हुआ, ये नहीं हुआ. That plea has been rejected by the court. And rightly rejected by the court. लेकिन मेरिट पे तो डिसाइड करना था ना, चाहे 1 पॉइंट लेता। अगर फर्स्ट अपील है ना, अगर मान लीजिए इतना भी लिख देता है that documents have not been properly considered, that itself is a ground for consideration. Because first appeal has to be decided in its own merit without even being influenced by the judgment passed by the judge.
The honorable court has to rewrite the judgment. That is the law.
Rewrite the judgment, reappreciate all the
All the
evidences,
evidence.
and come to its independent finding. And if the findings are concurrent, then the court would also see कि भाई ट्रायल कोर्ट ने क्या किया है, कॉन्करेंट है, उससे हम एग्री करते हैं। अगर मान लीजिए द कोर्ट कम्स टू अ डिफरेंट फाइंडिंग, उनको गलत लगता है, देन ही हैज टू डील विद द जजमेंट ऑफ द लर्नेड ट्रायल कोर्ट कि वो क्यों गलत है या क्यों सही। ठीक है, तो इफ देयर इज इवन 1 पॉइंट ऑन मेरिट, दैट हैज टू बी कंसीडर्ड। डिफेंडेंट नंबर 13 तो है ना भाई, ही इज ऑलरेडी देयर, तो उसका जो भी मेरिट था केस का, वो तो डिसाइड होना था ना, व्हाटएवर बी द मेरिट। 2 लाइन 4 लाइन फर्स्ट अपील में तो भी आप एकदम फ्री स्टाइल होता है फर्स्ट अपील। You cannot non-suit anybody, and there is an indication that he was contesting the case on merit as well. तो merit तो consider ही नहीं किया defendant number 13, right? This is what is the second substantial question of law. We have not entered into the point whether summons was served or not. वो तो हो गया conclude, but the court ought to have decided that case on merits.
The first appellate court has said in what not touching in the merit, the ground that my learned friend has read. The court has said that since the sale it was sold to the other sons, and it is their contention that the property has devolved to that person, that to the defendant number 2 to 11. That is the reason they are not required to be heard in this.
Defendant, who was defendant number 13? There are 3 sets of defendants.
They are brothers.
One is the defendant number 1,
जी.
who जिसके नाम से property. Defendant number 2 to 12 are his sons who have purchased the property. Correct?
जी.
And defendant number 13 कौन?
13 बुआ का लड़का है,
अच्छा,
बहन का लड़का है।
बहन का लड़का है। Why was he made party in this one?
Because
पूरा
फैमिली में बहन में आ गई ना।
अगर
अच्छा, बहन नहीं थी तो वो आ गया।
पार्टीशन सूट में जो मेरी बहन थी, तो
हाँ।
बहन नहीं थी तो बहन के डिसेंडेंट्स आ गए।
ठीक है,
तो बहन का भी तो राइट बना,
तो बहन रिप्रेजेंट मेरे फादर कर रहे हैं मेरी बहन को, मतलब डिपेंडेंट नंबर 1 की जो डॉटर है अपनेंट नंबर 1 है
आपको
उसका।
ऐसा लगता है कि एक पार्टीशन सूट में सिर्फ एक ही जनरेशन को पार्टी बनाने से चलेगा? बताइए, आपके घर में पार्टीशन होगा और आप पार्टी नहीं रहिएगा, आपके सिर्फ चाचा लोग और पापा लोग का सूट चलेगा, चलेगा क्या? Under Hindu law, a child in the family is born with a silver spoon.
My lord.
करेक्ट? तो उसको बिना पार्टी बनाए कैसे आप उसके ऊपर बाइंड करेंगे? मान लीजिए उसके पिताजी का शेयर हो जाता है 0, उसका भी खत्म। Once you say that it is a joint family property, you have to make everybody as a part.
ऐसे में कोपार्सनरी है,
कोपासनी 205 में आया, 2005 में कोपासनी। Now plea of कोपासनी is not available to the applicant. Before that, if the partition would have taken place, then the daughter is required to be made party. लेकिन जो कोपासनरी का जो है वो as far as date I remember, that is 5th of September 2005. That is the date on which the daughter has also been made co-partner to. Earlier they were having rights, no liability. Becoming co-partner, they have also liability upon the father's date and other.
नहीं, co-partnership right उनको मिला है 2006 में co-partnership right। 1956 में उनको अपने फादर के शेयर पर शेयर
लिमिटेड
co-partnership right जो है उनको मिला है 2006, right? So this daughter, if it is a 2003 का,
इवन इफ नॉशनल पार्टीशन हो फ्रॉम जो है उसका जो भी राइट है, एंसेस्ट्रल प्रॉपर्टी राइट तो मिला। अब फादर का जो शेयर होगा
she is a married daughter,
हमारी डॉटर है, इवन देन शी विल हैव द शेयर
From
और
her
जो
father.
नोशनल पार्टी, क्योंकि एंसेस्ट्रल प्रॉपर्टी के लिए हो रहा है, तो नोशनल पार्टीशन जब होगा
नहीं, नोशनल पार्टीशन अगर होगा, ठीक है,
तो भी हमको शेयर मिलेगा, हम पार्टी हैं,
तो शेयर फादर से लेंगे ना.
तो पार्टीशन होगा तो
this is just if notional partition is so decide कब हो?
So decided by date of assessment is my lord.
Decree signed on 6/1/2007.
That is ये December 20th December 2006.
अभी कुछ judgments आया है ना? What will happen if the daughter is born prior to 2006, prior to 1956?
उसका तो अलग है, 1956 के पहले तो आपको बचा नहीं होगा, उसके पहले
अगर मान लीजिए partition suit pending है, the partition suit was pending on the day when 2006 amendment came. Pending था उसे,
तो पार्टीशन तो जिस दिन हुआ तो फिर तो वो लॉ आ जाएगा,
वो लॉ आ जाएगा ना,
है
तो जजमेंट लाइए ना, हम तो भूल गए जाते, बहुत दिन से हिंदू लॉ नहीं करते,
तो हम तो लाए
कहाँ है
थे,
जजमेंट?
उसका पार्टी पे लाए थे, ये वाला इशू चूंकि नहीं उठा था, तो उस पे भी हो गया था कि 2006 के बाद अगर पार्टीशन डिसाइड होता है, बिकॉज़ पार्टीशन हैज बीन इफेक्टेड ऑन दैट डे बाय द डिक्री, द पार्टीशन हैज बीन इफेक्टेड, सो उसके पहले जब लॉ आ गया तो वो पार्टी फिर उसको शेयर मिला।
Since
ये
my
issue चूंकि उस
lord,
दिन
my
नहीं
lord is
उठा
that
था,
this issue has not been cropped up in the earlier argument. We have not worked out on
No,
this.
I understand that. अब देखिए ये डॉक्टर नेसेसरी पार्टी थी कि नहीं सूट, is the
Crux
core
of the
issue,
core issue.
right? If it was a suit for partition, according to you, she was not a co-pastor. She did not have co-pastory right on the day the suit was filed, therefore she was not made part. Let's take it for a moment that this is the situation. If the partition would have happened, her father would have got the share. Her father's share would be treated as a self-acquired property, and then the daughter would have got a share under the 1956. Right? This is the situation. But in a case where the suit is filed prior to coming into force of 2006 Act, and suit is ultimately decided after that, was she a necessary party?
That is required to research, my lord. Research. My lord, we frame this issue also.
नहीं, not required. Not required. ये तो हम तो बोल ही रहे हैं कि वो she said she challenged the partition suit saying that she was not made part. उसका जो भी इसका legal nuances होगा, interplay of 1956 Act and 2006 Act, what would happen in a pending suit? हमको लगता है ये issue decide हुआ है विनीता शर्मा. I think so. I think this issue has been decided in Vinita Sharma. I don't exactly remember which judgment, but there are judgments to this.
There are judgments to this. क्योंकि this issue has cropped up earlier also. कि क्या होगा जब एक्ट आने के पहले पार्टीशन हुआ?
बात ये है कि 2006 में the daughter gets a co-pastory right.
Co-pastory
right? If she becomes a co-pastor, then her right would relate back from her date of birth itself.
Right.
है ना? तो वो co-pastory right उसको date of birth से ही मिले. Therefore, she was a necessary party, subject to what judgments you get. आप लेके आइए, आपको मिल जाएगा ये judgment.
देखिए.
और इस पे आपको सबसे अच्छे से बताएंगे मिस्टर शर्मा, एसपी शर्मा. वो बहुत सारे यहाँ पर हमारे भी बहुत सारे जजमेंट्स हैं, हमको अभी याद नहीं.
बेसिकली इशू लास्ट टाइम में क्रॉप अप हुआ नहीं था और यही तो पॉइंट था, उसी पे खाली आर्गुमेंट बचा, उसी पे जजमेंट लाया. और ऑर्डर 41 टू 33 स्पेसिफिकली बोलता है कि अगर अपील प्रेफर हो गया अब मान लीजिए कि देर आज
Appeal is otherwise also a continuation of.
कंटिन्यूएशन है और उसके बाद ये भी बोलता है कि अगर कोई दूसरा सूट भी है, क्रॉस सूट है, ये है, वो लोग अपील कोई फाइल नहीं की। इवन दैट the appellate court has to see everything and court has every power to vary, reverse or modify the decree of the trial. So
that
once
is the law.
appeal is there,
In one line, the law is the appellate court has to rewrite the judgment on the every issue.
That's right.
Either on the same issue or framing the point of determination. They have. That's why the first appeal is the right of the appellant to be admitted. That's why in every day, my lord, first appeal admit call for the LCR. This order is being
the routine order.
Routine order.
So we pause here at this moment. You find out that judgment both of you. What is the consequence if a suit was pending on the coming into force of 2006 Act?
Well,
and what is the date of commencement of 2006 Act? What is that cutoff date? क्योंकि ये सूट डिसाइड हुआ है 20 दिसंबर
2006
I think it came back.
That's why I remember the date. Though 2006 Act is there, but the date I remember that is the 5th of September 2005. I'll cross check it.
5th of September 2005.
As far as my memory goes.
That's right. If the appeal was pending, if the suit was pending on the date of coming into force of 2005 amendment, then by virtue of the amendment, I think so, the little that we have decided a few cases. The suit, all the co-partners, by virtue of this particular provision, in a pending suit, are to be acted. And if that be so, the appeal, the matter has to go to the appellate court, or we can remand it even to the trial court. The reason being that now she has a right to file the
WS. It would be better to remand it to the trial court.
There is no point remanding it to the trial court. To the appellate court. उससे कोई फायदा नहीं, क्योंकि उनको फिर रिमांड ही करना पड़ेगा. फर्स्ट एपेलेट कोर्ट में तो रिटन स्टेटमेंट आएगा नहीं आएगा. इट हैज टू कम एट द ट्रायल स्टेज. अभी वो लोग सब आ नहीं रहे. कहाँ हैं? जो लोग यहाँ रेगुलर सिविल करते हैं उनको कोई दिख नहीं रहा. तुरंत बता दो. कौन? आप हैं? इधर आइए. शर्मा जी के साथ है ना? इधर आइए. देखते हैं कितना सीखे. इधर कम से. Daughters in the family has got co-custody right under Hindu law. Yes or no?
Yes.
कब से? तब तो आप सीख ले रहे हैं. हम कल रख देते हैं. आप लोग जजमेंट ले. आप लोग जजमेंट ले. ठीक है? The parties have commenced their arguments. During the course of hearing, it transpired that title suit number 5 of 2003, title partition suit number 5 of 2003 was decided on 20th of December 2006. And by this time, the 2005 amendment, 2006 amendment. 2006 amendment had come into force. The daughter of defendant number 1 filed the appeal claiming that she was not made party in the partition suit. The property was standing in the name of defendant number 1, and the plaintiffs claimed partition of the said property by asserting that it was a joint family. the learned counsels submit that they may examine the provision of law further as to whether upon coming into force of 2006 amendment in Hindu succession law in a pending suit, the daughter was required to be made a party in the proceedings. Okay? कल ज्यादा टाइम नहीं लगेगा, आप
खाली
जाइए।
सारे 2 जजमेंट देना, खाली प्रे ज्वाइंटली करें मंडे के लिए इसको।
नहीं देखिए कंटिन्यूटी में सुनते हैं।
ठीक है, तो परसों के लिए कर दीजिए।
नहीं परसों, कल ही आपको आना हो, परसों नहीं। और आप जाइए मिस्टर एस शर्मा विटल, उनका बहुत सारा हिंदू सक्सेशन एक्ट से मोस्ट ऑफ देम हैव बीन अपहेल्ड आल्सो, किसी में नोटिस
कल तो 15
दो tomorrow at 2:15 as first class. तो जरा बोलिए तो विनीता शर्मा हो जाएगी। विनीता शर्मा बहुत फेमस है। हाँ होगा ये।
Item 2, first appeal 154 of 2023.
Have entered the wakalatnama on behalf of the family.
You are satisfied?
Yes. I had all the notes and thereafter notes. I have taken their
You have filed
signatures
it?
in front of me. Today itself notes I have entered the wakalatnama. Yes.
Now you can argue the case.
So I will seek some time notes to examine everything notes and prepare a short note. And thereafter notes may fix any date for notes.
Why do you need time?
But I do not have access to the series notes particularly. I have taken notes, the LCR's copy notes. Series notes are missing and that will be vital.
Sale deeds are missing, yeah, missing तो कुछ नहीं होता।
The scanned data that has to be
देखिए
examined.
इतना ज़्यादा हम लोग आपके लिए नहीं कर सकते। स्कैन नहीं है तो आपको यहाँ पे देखना
In
चाहिए।
the first place, I have asked them only to give me the copy.
Prepared a short note of facts.
नहीं आप आज भी शुरू कर दो, हम इसको पहले नहीं कर सकते। We'll read the plaint and the written statement, right? Limitation delays कर लो।
Partitions.
Just a moment. You have entered the appearance on behalf of responding number? All the respondents. Learned counsel for the respondents. Naam बोलिए।
Mr. Parth.
Mr. Park Jalan submits that he has entered appearance on behalf of all the respondents. चलिए थोड़ा plain written statement देखते हैं। वो दीजिए जरा, record। Yes. First tell me, is genealogical table under dispute?
No, Lordships. It's not in dispute. We have
Not in
filed it
dispute.
along with the claim.
Schedule 2 of the plaint is the genealogy.
Sorry,
Schedule 2 of the plaint is the genealogy.
we'll have it. Partition C series of 2017. Okay. Let us see the schedules.
Schedule of the page 12. Schedule 1. Genealogical
Page
chart.
12. Okay.
Dinanath
Who are
Singh.
the plaintiffs?
Plaintiffs are Lordships Bajanti Singh, Sunil Kumar, Sudhir Kumar, Neetu Singh. They are the sons and daughters of Lalpari Singh.
Anil Kumar is also the plaintiff.
Anil Kumar Singh, he died Lordships prior to filing of this suit. His wife,
Premshila
his
is
wife
the
and
plaintiff.
his wife,
Premshila, Bajanti, Sunil Kumar, Sudhir Kumar, and Neetu Singh are the plaintiffs.
plaintiffs are not Premshila Lordships. She is the defendant number 1. She is
Oh,
contesting this.
She is defendant number 1. She is the contesting.
And defendant number 2 to 5 are her sons and daughters.
Okay. All right.
And
Plaintiffs are
the
Bajanti,
Bajanti,
Sunil,
Sunil,
Sudhir, and Neetu.
Jesus.
Okay.
They are the sons and daughters of Lalpari.
Okay. Where is the schedule of the property?
Schedule of the property, schedule 1, page 11. Is situated at 13 Bharatpuri, Purulia Road under Lalpur Police Station.
Lalpur, Ranchi.
Total area 2 Kattha, 6 Chhata, plot number 6162, farm number 198. On the opposite hand is constructed one floor house about area of 1500 square. This house was constructed at the time of purchase of this property in the year 1987 itself.
Now let us see that you read the page.
Plain from para 1. That from the genealogical table given at the top, at the foot of this plain, we will note that plaintiffs, namely Sri Sudhir Kumar, Srimati Gajanti Singh, Sri Sunil Kumar, Srimati Neetu Singh are the brothers and sisters of late Sri Anil Kumar Singh. All are the sons and daughters of late Sri Dinanath Singh and late Srimati Lalpari Devi. It may be pertinently noted here that Srimati Premshila Devi, who is the wife of late Anil Kumar Singh, has been included as defendant in this suit for partition. As the suit scheduled property described in the plain was purchased by late Sri Dinanath Singh in the name of his wife Srimati Lalpari Devi by way of registered sale deed from one Sri Govindra. The seller Sri Govindra had transferred the suit scheduled property in the name of Srimati Lalpari Devi, wife of Sri Dinanath Singh. It may also be noted that defendant, namely Srimati Premshila Devi, wife of Sri Anil Kumar Singh, who was the brother of plaintiff and deceased son of late Sri Dinanath Singh and Srimati Lalpari Devi, is presently residing solely in this scheduled suit property. It may be necessary to mention here that during the lifetime of Srimati Lalpari Devi, owner of the property, all her children lived together in the suit scheduled property except Srimati Gajanti Singh, who got married prior to the purchase of suit scheduled property. It may be noted here that Srimati Gajanti Singh is the plaintiff number 2 by virtue of being the eldest daughter of late Sri Dinanath Singh and Srimati Lalpari Devi. It may be mentioned here that during the lifetime of Srimati Lalpari Devi, owner, her children had shifted to different places for their respective occupations to earn their livelihood, except her eldest son, wife, and children, who have been residing continuously in the scheduled suit property. The other children of the owner, Srimati Lalpari Devi, who are the plaintiff in the suit, has their respective rooms in the scheduled suit property, where they used to come and reside at regular intervals, and their rooms used to remain locked during their absence in the property. It may be pleaded here that the husband of Srimati Premshila Devi, namely Sri Anil Kumar Singh, late Sri Anil Kumar Singh, had died during the lifetime of his mother, Srimati Lalpari Devi, owner of the suit scheduled property. It may be noted here that late Sri Anil Kumar Singh, son of late Dinanath Singh and late Lalpari Devi, had died leaving behind his wife namely Premshila Devi and 4 children, who presently resides along with her 4 children and continues to reside till date. In the meantime, within the period of her stay of Srimati Premshila Devi has broken the locks of other rooms which were possessed to the brothers and their families, and has illegally obtained the possession of the suit scheduled property. That it is the settled principle of law that after the death of late Sri Dinanath Singh and Srimati Lalpari Devi, owner of this suit scheduled property is liable to be jointly succeeded by the plaintiff and defendant in the capacity of being the legal heirs of in accordance with law and envisaged in the Hindu Succession Act 1956. that the defendants is the wife of late Shri Anil Kumar Singh, was the eldest brother of late Shri Dinanath Singh and Srimati Lalpari Devi owner, and has been taking care of the suit scheduled property on behalf of the other legal heirs from the lifetime of Srimati Lalpari Devi owner. It was during this period that when the other legal heirs were residing away from home with their respective families, Srimati Premshila Devi defendant has rented their rooms to tenants by breaking the locks of their rooms without informing the other legal heirs, and has been collecting rents from these tenants. That during the lifetime of father and mother, also the defendant, elder brother and wife collected removable property rent in the name of his mother. The detailed description of the property existing in the name of his mother in law of his defendant is also given in Schedule 2 of the claim. That the suit scheduled property left behind by the owner, Srimati Lalpari Devi, is liable to be partitioned equally between all legal heirs, 3 sons and 2 daughters. It will be mentioned here that the eldest son, namely Sri Anil Kumar Singh, is survived by his wife and 4 children, and thus the division of property to the extent of 1/5 share shall be entitled in the name of Srimati Premshila Devi and her 4 children. That the plaintiff has to spend huge amount to upkeep the house period, but the defendant is enjoying the house without giving a single farthing to the plaintiff. Hence, it is not possible for the plaintiff to keep the property in joint lease. That the plaintiff has got unity of title and possession with the defendants over the entire property detailed in schedule of the claim. Plaintiff has got 1/5 share of every plaintiff as brothers and sisters over the entire property scheduled in the schedule of claim. And that the plaintiff feels great inconvenience in remaining joint with defendant, hence he requested them to partition the whole suit property, but they always refused to partition of the property. The cause of action of the suit arose on 29/6/2017 when the plaintiff claimed the partition of the suit property, and lastly on 5/7/2017 when the defendants refused the same to the possession to the joint property for partition. The suit was valued as 75 lakhs.
This suit has been dismissed.
This suit has been dismissed
On what ground?
on the ground that the plaintiff was unable to prove the title, joint title of the plaintiff and defendant over the suit property, and that issue was also not framed by the learned trial.
Joint title of the plaintiff. The property was standing in name of Lalpari Devi.
It is also admitted by the defendant in their written statement, and also the
Yeah,
learned trial should
क्यों नहीं होगा भाई?
Because there is a dispute pertaining to other ancestral properties also. There is a specific pleading that selectively one property has been included in the partition.
No, you see, and this is not an ancestral property. This is not an ancestral property because the property was purchased in the name of Lalpari Devi. It was standing in the name of Lalpari Devi. तो ये joint family property कैसे हो?
There is no pleading to this effect that the property.
Ancestral property कैसे होगा? Joint family तो है. How is it ancestral property? There is a difference between ancestral property and joint family property.
Joint family property is that it was purchased from the common person.
ऐसा तो नहीं है.
वैसा कोई pleading नहीं.
वो ancestral property हो जाए. ऐसा तो ना कोई pleading है ना कोई कहानी.
वैसा कोई नहीं.
Then
They are also claiming by way of inheritance.
yes, maybe all inheritance is not with respect to joint family property. There is a difference between joint family property and ancestral property. तुम्हें थोड़ी है. Succession and And what was the written statement?
written statement private case. The from para 7 they have raised the one to para 7. Para 7 they have said that the suit is barred is bad for non-finder of ancillary party. That the khata number 394 is recorded in the name of Ramdev Singh, Dinanath Singh, son of Ram Kishore Singh, 1 share, and Ambika Singh, son of Harihar Singh, 1 share, and Rajan Singh, son of Gauri Singh, 1 share, 0.05 acres, 0.02 decimal, and khata number 392 has been recorded in the name of Ramdev Singh and Dinanath Singh, son of Ram Kishan Singh equal share. Khata number 390 has been recorded in the name of Ramdev Singh and Dinanath Singh, son of Ram Kishan Singh. Khata number 393 has been recorded in the name of Ramdev Singh and Dinanath Singh, son of Ram Kishan Singh, 1 share, and Rajan Singh, son of Bodha Singh, 1 share. Khata number 133 has been recorded in the name of Bodhi Singh, Bodha Singh and Kishan Singh, son of Dhanuki Singh, and Khata number 134 has been recorded in the name of Dhruvi Singh, Dhandu Singh, Kishan Singh, all son of so all tracts of Khata are situated at village Revai, district Gaya. These are properties which they are saying that these are also the property of the ancestors, in which the name of the father of the plaintiffs and his brothers are mentioned. That should also be partitioned. And so far as their admission is concerned, para 10 they have said so. That the statement made in para 2 of the claim is partly admitted and partly denied. It is true that this property described in the claim was purchased by late Dinanath Singh in the name of his wife, Srimati Lalpari Devi, by way of registered sale deed. During the lifetime of Srimati Lalpari Devi, all the legal heirs of Lalpari Devi lived together in this property, except Rajanti Singh, who got married prior to the
Para
purchase.
number?
Para number 10,
Page 4.
page 4.
पढ़िए पहले।
That the statement made in para 2 of the claim is partly admitted and partly denied. It is true that the suit property described in the claim was purchased by late Dinanath Singh in the name of his wife, Srimati Lalpari Devi, by way of registered sale deed. During the lifetime of Srimati Lalpari Devi, all the legal heirs of Lalpari Devi lived together in the suit property, except Srimati Bajanti Devi, who got married prior to the purchase of the suit property. During the lifetime of the Srimati Lalpari Devi, her children had shifted to different places for their respective occupation to earn their livelihood. The defendant have been residing continuously in the suit property.
Judgment बताइए। What judgment has been passed? Let's have a look at it.
Judgment Lordships, internal page number 12. Running
What
page number,
issues were framed?
issues were framed, Lordship. That
That is
issue
page 6.
page number, internal page number 6. Para 4. उभय पक्षों के वाद पत्र एवं लिखित कथन के आधार पर जो विवाद का बिंदु है उसके आलोक में दिनांक 13/2/2020 को वाद पद का गठन किया गया, जो वाद पद निम्न प्रकार से है। क्या वादी का वाद पोषणीय है? क्या वादी को उचित वाद का कारण उत्पन्न हुआ है? क्या वादीगण एवं प्रतिवादीगण के बीच कब्जा की सामूहिकता एवं स्वत्व की एकता है? क्या वादीगण एवं प्रतिवादीगण नालसी जमीन के संबंध में सह हिस्सेदार हैं? क्या वादीगण का वाद परिसीमा अधिनियम से बाधित है? क्या वादीगण का वाद विवद परित्याग एवं स्वेच्छा से परित्याग के विधि से बाधित है? क्या वादीगण का वाद आवश्यक पक्षकार का असंयोजन या उस संयोजन में दोष है? क्या वादीगण के द्वारा वाद का उचित मूल्य निर्धारित किया गया है? क्या वादीगण किसी अन्य प्रकार के अनुदोष या अनुदोषों को पाने का हकदार है?
So the relevant issues would be Roman 3
And 4.
And
and 4, right? 3 and 4, how it has been decided?
prior to 3 and 4, Lordship, the trial court has gone into the issue of title of the plaintiff. That issue has never been framed by the learned trial. So, Lordship, may kindly come to internal page number 12. Turning page number 14.
Neither any issue of title has been framed, nor there is any dispute on it.
There is no dispute regarding it.
That is part of issue number 3 and 4 itself. That starts from page number 11.
That is regarding the unity of title and possession.
Unity of title and possession.
But it is part of, I'm just saying that.
In your written statement,
Yes.
there is no dispute
I
that
am
the
not
property
disputing
was
Yes.
purchased by Dinanath Singh in the name of his
Wife.
wife. And they are claiming devolution of the property which was standing in the name of wife of Dinanath Singh. The genealogy is not in dispute.
Genealogy is right.
The plaintiff, they are claiming that 1/5 share for each of the plaintiff should come. And the defendant is one of the sons,
Wife.
She is the wife of one of the daughter-in-law of the.
daughter-in-law and her children.
They will get one page.
And her children. Total, all of them would get 1/5.
One.
Okay, let's see.
dispute is because that
Page
not
number
all the
40.
properties have been taken into consideration. One selective property, that is the scheduled property one, has been taken. Partition has been filed only for one particular property.
What is the definition of an ancestral property? For the purposes of claiming partition of ancestral property, every property has to be taken into consideration. Is it so even for the purposes of partition of joint family property? Let us see the findings.
Page number 40, running page number 14, turning page number 12. So after the highlighted part, वर्तमान मामले में वादीगण के द्वारा इस बात का कथन किया गया है कि प्रतिवादीगण एवं उनके बीच कथित भूमि का बंटवारा नहीं हुआ। सर्वप्रथम वादीगण जिस भूमि के लिए बंटवारावाद लाया है उसे यह साबित करने का दायित्व है कि भूमि का स्वामित्व उनके पास है और वादीगण एवं प्रतिवादीगण दोनों भूमि का स्वामित्व रखते हैं। वादीगण यह कथन नहीं कर सकता है कि प्रतिवादीगण साक्ष्य प्रस्तुत करें तथा प्रतिवादीगण के साक्षियों के कथन में कमियों का फायदा वादी को नहीं दिया जा सकता। यहाँ पर धारा 102 साक्ष्य अधिनियम का उल्लेख करना चाहूंगा जो साबित करने का भार के विषय में कहता है कि जब वादी के द्वारा अपने वाद में जो साक्ष्य प्रस्तुत किया गया है और अपने वाद को साबित किया है तत्पश्चात साबित करने का भार प्रतिवादीगण पर जाएगा। वादीगण जो भूमि केवट नंबर 3 खाता नंबर 167 प्लॉट नंबर 6162 थाना नंबर 198 मौजा उनका जिला रांची की भूमि है वह जमीन वास्तव में वादीगण प्रतिवादीगण का है यह साबित करने का दायित्व वादीगण को जाता है क्योंकि वादीगण के द्वारा जिस भूमि का बंटवारावाद लाया गया है वह भूमि स्वर्गीय दीनानाथ सिंह के द्वारा अपनी पत्नी स्वर्गीय लालपरी देवी के नाम से खरीदा गया है। यह साबित करने का दायित्व वादीगण को साथ ही साबित करने का दायित्व वादीगण को है कि उनके माता पिता की मृत्यु के पश्चात नालसी जमीन संयुक्त रूप से है। वादीगण ने यह कहते हुए वाद लाया है कि जमीन वादीगण एवं प्रतिवादीगण के मां के नाम से खरीदा गया है लेकिन वादीगण के द्वारा जहां तक कि किससे खरीदा गया उसका विक्रय विलेख संख्या क्या है वह भी अपना वाद पत्र में उल्लेख नहीं किए गए। मात्र यह कहना कि नालसी जमीन उनके माता पिता के द्वारा क्रय किया गया है यह स्वीकार योग्य नहीं है। साक्ष्य के दौरान वादीगण के द्वारा विक्रय विलेख संख्या 45-65 वर्ष 1987 का प्रमाणित पत्र दाखिल किया गया है लेकिन इस वाद पत्र में उल्लेख नहीं है कि क्यों विक्रय विलेख वाद दाखिल करते समय वाद पत्र का उसका उल्लेख नहीं किया गया जो कि साक्ष्य के दौरान प्रदर्श 1 के रूप में अंकित किया गया। ऐसी स्थिति में वादीगण स्वयं अपनी वाद पत्र में विरोधाभास उत्पन्न करते हैं। इसके अतिरिक्त प्रदर्श 1 के अलावा कोई और दस्तावेज दाखिल नहीं किया गया है जिससे कि इसकी संतुष्टि हो कि पक्षकारों के माता पिता के द्वारा उचित एवं सक्षम विक्रेता से क्रय किया गया। मात्र विक्रय विलेख से स्वामित्व का अंतरण नहीं होता जब तक कि भूमि जमीन सक्षम विक्रेता के माध्यम से क्रय नहीं किया गया। प्रदर्श 2 वादीगण के द्वारा थाना प्रभारी लालपुर खिटिया का आवेदन है जो इस बात के में साक्ष्य के दृष्टि से महत्वहीन है। क्या वे सभी खाता प्लॉट की जमीन का मालिक थे एवं उनके पास दखल कब्जा था। वादीगण को यह कथन को साबित करना होगा कि जिससे जमीन खरीदा गया उसे बेचने के लिए वे हकदार थे। इस संबंध में संपत्ति अंतरण अधिनियम की धारा 7 का उल्लेख करना चाहूंगा कि इस प्रकार हर व्यक्ति जो संविदा करने के लिए सक्षम हो एवं अंतरणीय संपत्ति का हकदार हो या अंतरीय संपत्ति जो उसके अपनी नहीं हो व्ययन के लिए प्राधिकृत हो ऐसी संपत्ति का अंतरण पूर्णतः तथा अत्यधिक रूप से या सशर्त उन परिस्थितियों में अपने विस्तार तक और उस प्रकार से जो किसी भी तत्समय प्रवृत्त विधि द्वारा अनुज्ञात और विधित को करने के लिए सक्षम है। विधि का यह विदित सिद्धांत है कि कोई भी व्यक्ति अपने हक से ज्यादा या उसके पास है उससे ज्यादा किसी को नहीं दे सकता। इस बात की पुष्टि हेतु वादीगण के द्वारा कोई दस्तावेज जैसे कि मालगुजारी रसीद दाखिल खारिज से संबंधित दस्तावेज पंजीकृत खतियान भी दाखिल नहीं किया गया है। इसे यह स्पष्ट हो कि वादीगण के द्वारा जिस जमीन पर बंटवारा का मांग किया गया है उससे वे या उसके पूर्वज विधि हकदार से खरीदे हैं। उसके समर्थन में ना तो कोई मौखिक साक्ष्य ना ही कोई महत्वपूर्ण दस्तावेज दाखिल किया गया है, जिससे यह इस बात की संतुष्टि नहीं होती है कि लालपरी देवी जिसने जमीन खरीदा था क्या वास्तव में उस जमीन का गोविंद राम हकदार थे। इस बात की संतुष्टि बिना खतियान या अन्य दस्तावेज के बगैर असंभव है। वादीगण अपनी ओर से मौखिक साक्ष्य भी प्रस्तुत किए हैं, लेकिन दीवानी वाद में जहां वाद बंटवारा हो, उसमें हक की एकता एवं कब्जे की सामूहिकता का प्रश्न हो, उसे साबित करने में दस्तावेजी साक्ष्य के स्थान पर मौखिक साक्ष्य से उसे प्रतिस्थापित नहीं किया जा सकता। प्रतिवादीगण की ओर से उपस्थित होकर यह स्वीकार किया गया है दोनों पक्ष एक ही परिवार के सदस्य हैं और उनके माता स्वर्गीय लालपरी देवी के नाम से उनके पिता दीनानाथ सिंह ने क्रय किया है, लेकिन मात्र यह स्वीकार कर लेने मात्र से ये साबित नहीं हो सकता है कि उस संपत्ति पर स्वत्व वादीगण एवं प्रतिवादीगण का है, जिसका वे बंटवारा हेतु वाद लाए। प्रतिवादीगण की ओर से साक्ष्य के दौरान प्रदर्श ए खाता संख्या 394 प्रदर्श A/1 का खतियान खाता नंबर 392 एवं प्रदर्श A/2 खतियान खाता संख्या 393 एवं प्रदर्श A/3 का खतियान खाता नंबर 134 जो ग्राम रेवई थाना केतारी जिला गया, जो इस बात से कोई संबंध नहीं रखते हैं और साक्ष्य की दृष्टि से कोई महत्वपूर्ण वर्तमानवाद के लिए नहीं है। वर्तमानवाद का नालसी जमीन उनका मौजा रांची का जमीन है, उसे साबित करने के लिए ऐसी कोई दस्तावेज दाखिल नहीं किया गया जिससे साबित हो कि नालसी जमीन पर वादीगण एवं प्रतिवादीगण संयुक्त स्वामित्व एवं कब्जे की समरूपता है। विक्रय विलय की सच्ची प्रतिलिपि बंटवारावाद में जब तक हक की एकता एवं कब्जे की समरूपता साबित नहीं हो जाता है, तब तक बंटवारावाद में वादी के पक्ष में डिग्री नहीं दिया जा सकता। वादीगण वाद को साबित करने में पूर्णतः असफल रहे। उपरोक्त तथ्यों के अवलोकन से इस निष्कर्ष पर पहुंचता हूं कि वादी जिस जमीन का बंटवारा हेतु वाद लाए हैं, उस पर वो अपना अधिकार साबित करने में असफल रहे हैं और विधि का यह सिद्धांत है कि वादी उसी भूमि पर बंटवारा का वाद ला सकता है जिस पर उसका हक स्वत्व और हित हो। चूंकि वादी जमीन भूमि पर अपना हक स्वत्व और हित साबित करने में असफल रहा है, ऐसी परिस्थिति में कब्जा की सामूहिकता एवं सर्व की एकता का प्रश्न ही नहीं उठता है। साथ ही जब तथ्य साबित नहीं होता है, तो वर्तमानवाद के लिए पक्षकारगण सह हिस्सेदार हैं, इसका कोई महत्व नहीं होता है, क्योंकि कोई पक्षकार एक सह हिस्सेदार होने मात्र से वे बंटवारा का हकदार नहीं हो जाते हैं जब तक कि विवादित संपत्ति में हक की एकता एवं कब्जे की सामूहिकता साबित करने पर नहीं कर लेते। इस विषय पर चर्चा तब उचित होगा जब वादी के द्वारा उस जमीन पर अपना हक की एकता एवं कब्जे की सामूहिकता साबित करेगा। अतः उपरोक्त दोनों वाद पद 3 एवं 4 के बिंदु पर वादीगण के विरुद्ध निर्णय लिया जाता है।
He has entered into the title dispute.
That too which has not been disputed by the
Please look into the title as well.
Neither unity of title, neither title, nor unity of title, nor unity of possession is in dispute. But the court has entered into this dispute.
No, issue of possession because that is disputed.
In order to prove possession, is it necessary to have documentary evidence?
Even in the overall evidence, because they have also admitted this fact that all of them had left for Delhi.
That's right.
That is because Delhi
That is unity of possession. Even if you are living somewhere, your ancestral property, your joint
for the purpose
family,
of partition, because
as long as the family is joint, you are in joint possession of
There is
it.
a presumption not to be when one person is in possession of the property, he is in possession on behalf of the all other property.
but my the argument which was advanced by me, in that case, that has also been completely ignored. My case is, that apart from this property, the scheduled property, there are other properties
That
also.
issue has also not been framed.
That issue has not, but that would also be an essential issue which had to be looked into.
That's right. We are not going to frame an issue over here. Can we frame an issue over here and take evidence?
Not
because you see, you do not know how this property was acquired. And whether the nature of property would be joint family property or ancestral property. Are all the ancestral property to be included in the partition of a joint family property?
Even with respect to the property which I am claiming, in para 7 of my written statement, in-depth cross-examination and examination was done with respect to that. So there are starking contradictions with respect to that property.
You see, the court has not gone into those issues. Those issues were not framed also. that whether the suit was barred for partial partition.
Because in my most humble submission,
That issue has not been framed. Whether the suit is barred for partial partition, that issue has not been framed.
but while this honorable court, as the first appeal,
So we will not. You see, I will not remand the matter just like that. Since the point is that if issue is not framed, parties will have to lead evidence.
evidences have been led or with respect
No,
to that.
there is no issue framed. Without framing an issue, how do you say evidences have been led?
Because there is a specific pleading with respect to that in my written statement. In support of that pleading, at least with respect to the property,
You
which
see,
is there at
first
Dara.
there is a plain written statement,
Yes.
then issues are framed,
Yes.
and parties lead evidence with respect to each of the issues,
Yes.
keeping in mind each of the issues. There is no issue framed as to whether the suit was barred on account of partial partition.
Not specifically with respect to partial
But
partition,
partial
but then the maintainability
This is what you wanted to plead, isn't it? That
Yes.
there are other properties also, and those have not been included. Whether the suit was barred on account of partial partition.
that would go to the maintainability of the suit itself. Specific issue with pertaining to maintainability, as well as misjoinder and non-joinder of the parties has been framed by the court, though not looked in.
Not at all.
No, issues pertaining to maintainability and non-joinder that has been framed. Will kindly consider internal page number 27 and 28 of the.
You see, the point is that a general issue, whether it is maintainable, is not sufficient. The issue ought to have been whether the suit was bad for partial partition. That has to be a specific issue, not maintainable. Or how do you say non-joinder of necessary party? Everybody is there.
I am putting a question to myself is that if there are pleadings to this effect, that there are other properties. If specific evidence, oral evidence has been oral and documentary, both has been led with respect to that particular point. The court ought to have decided that issue either as a specific issue or as part of maintainability.
Maintainability is too wide a issue. It will not include whether the suit was bad for non-inclusion of other properties. We do not know whether it is a joint family property, whether it's an ancestral property.
It appears to be ancestral property
They are also
because the name of the brothers of the fathers of the plaintiffs and defendants, those names are appearing in the record of rights. And this appears to be ancestral property, and they cannot be included as party in this particular suit because this suit is not ancestral property.
This is not an ancestral.
Joint property. And that property is also situated outside the jurisdiction of the state of Jharkhand.
What is the definition of an ancestral property?
Ancestral property is coming from those who are
It is not common sense definition.
not
It is not common sense definition, okay? it is nobody's case that the common ancestor had bought the property from his ancestral property. That is not the case. The simple case is that he bought the property in the name of his father.
The
It is
property was in the
nobody's
name
case
of
that he never had any income.
one moment.
It is nobody's case that he had purchased the property by selling off any ancestral property. It is not the case that he acquired this property by virtue of some income from the ancestral property. That is not the case.
But with respect to the property for which I am stating, Lords, there is specific. If I may place one or two statements, Lords, from the oral evidence of plaintiff number 1. That, Lords, is there at page number 81, running page number 81.
What is the date of purchase?
1987 of the date is
Date of purchase is 1987.
year is 1987.
Date of purchase of the property.
Date of purchase 27/5/1987.
Read section 14 of Hindu succession.
Property of a female Hindu to be her absolute property. Any property possessed by a female Hindu, whether acquired before or after commencement of this act, shall be held by her as full owner thereof, not as a limited owner. In this explanation, subsection property includes both movable and immovable property acquired by a female Hindu by inheritance or otherwise. That is
So any property standing in the name of the female is her property as absolute property.
Her
Her property.
Yes, but then when
If it is her property, it is not an ancestral property.
her
It will
property-
not devolve as an ancestral property. How the property of a Hindu female devolves is also provided.
Section 50.
Yes, you see section 50. Just see.
So then in that case, Lords, it will come
And
upon
she
firstly-
has, yes, first it has to
firstly
go
upon the sons and daughters.
sons and daughters.
and the husband.
Firstly upon the and the
Sons and daughters.
and the yes.
Right? So there is no question of any agnates of the husband to claim any property, any share out of it. What you are saying through your written statement is that there are other ancestral properties in which the names of agnates are also appearing. Correct? Those agnates have nothing to do with this property. And they will not have a share on this property.
But that is what I was submitting, that it is his admission, the PW1 Lords, who is also one of the plaintiffs before the Lordships, Lords, that property also, the property which was there at Gaya, that was also partitioned amongst the ancestors. So once, Lords, it has been partitioned amongst the ancestors, and they say that whosoever had the interest had they have come in possession of that property. Thereafter, it will that particular property which falls, the share of which falls in uh, in the share of Millard's, the father of
Father has nothing to do.
the husband of Millard's Lalmani
Husband has
Devi,
nothing to do.
that Millard's in my most humble submission will come within the purview of the partition.
No. How this property will be treated as a property of the husband?
Your Lordship, if the property was not inherited by these plaintiff and defendants, the property could have been gifted by the mother as well to some other person, but it was herself acquired property. And in the ancestral property, a person derives a right by birth, and that property they will have the share. But in this case, neither the plaintiff nor the plaintiff or the defendants can say that they had the right over the property by birth. Since it was the self-acquired property of the mother, she could have gifted the property to a particular person as well. This cannot be termed to be a ancestral
Once
property.
partition has been effectuated with respect to the other property, but that would also come within the definition of self-acquired property once partition has been effectuated.
And apart from this, the trial court has not dealt with the core issue at all. Has gone into the title dispute.
Only with respect. That I cannot dispute. That is there on record, but that I cannot dispute.
So under such circumstances, the judgment cannot sustain. The court has not gone into the issue at all. How do you sustain this judgment?
My submission would be, Milords, that important aspects of the matter, Milords, which have been pleaded, Milords, and specific evidence has been led with respect to that, Milords, that has also not been looked into by the court.
So they will look into whatever it is. They look into if any additional issue is required to be framed. They frame an additional issue. Give you the opportunity to lead evidence.
Lord, even the partial partition is allowed in the cases where, Lordship, the ancestral property, other properties are not ready for partition, not in possession of the person concerned, or if the property is outside the jurisdiction of the court, Lordship, who is dealing with the matter. Because, Lordship, in the property of Gaya cannot be matter of sub judice before this honorable or the matter before the learned trial. That is of different jurisdiction.
The issue of partial partition has not been raised.
That has not been
It
raised.
has got lot of nuances. It is not a straightforward issue. It has got lot of nuances. Whether the suit was bad for partial partition, a specific issue was required to be framed to that. And what is the nature of the property? Whether it was joint family property or it was an ancestral property. The point that whether the suit was barred for partial partition would include the entire bundle of issues.
Then specific pleadings and evidence with respect to that has been led, then that issue may also have been.
Pleading is there.
Yes.
That it is bad for partial partition. That pleading is there, right? But no issue has been framed.
No issue has been framed. No specific issue with respect.
No issue has been framed on that count. So, whether this particular property has been subject matter of partition in any other suit?
No, that has not come in the evidence.
That because it has come in their evidence that it has already been partitioned earlier, but then during cross-examination it has been said that I cannot produce any
It has mentioned that
any
it
document
was
pertaining to the same. It was an oral
oral
partition.
partition. That was not true.
And what I have in my cross-examination, I have specifically stated that deliberately only one partition, only one property has been made a part of this particular plate, while excluding the property at Gaya because that is a valuable piece of property generating major agricultural income.
पेज नंबर 10 संपूर्ण जमीन का बंटवारा नहीं होने पर वाद का अंत नहीं होगा। वादीगण को संपूर्ण जमीन के बंटवारे हेतु वाद लाना चाहिए। पेज नंबर 10 जो फर्स्ट पैराग्राफ है जस्ट उसका 2 लाइन लास्ट 2 लाइन्स।
So it is the evidence of the PW. She has said so.
Yes.
Again, that property, as per their assertion also, that is running in the name of the forefathers and other brothers of the plaintiff and the defendants. She has also not mentioned that property was partitioned thereafter. As far as they are concerned, they had no right over the property, which is subject matter of the estate. So far as partial partition is concerned, Lordship, I may place one judgment from the Supreme Court of India. It says, Lordship, that the partial partition cannot be said to be completely barred in each and every situation. It also has exceptions such as, Lordship, the property is not within the possession of the co-partners, or if the property is situated outside the or in different jurisdiction of the across the state, across the country, then Lordship, that property can be exempted and partial partition can be.
ये immunity वाला point अलग से decide किया है?
That has अलग से नहीं decide. मतलब
1 Roman 1.
उसी के that is at page number 15. para 13. वादीगण के वाद वर्तमान स्वरूप में पोषणीय है. वादी जिस भूमि का बंटवारा वाद लाया है उस पक्ष में यह साबित करना असफल रहा है कि उस भूमि में उनका स्वामित्व है, इसलिए वादीगण का वाद वर्तमान स्वरूप में पोषणीय
Because he
है.
was not able to show his title.
क्योंकि वाद तभी पोषणीय होगा जब वादीगण जिस भूमि में बंटवारा वाद लाया है उस पर हक हो, क्योंकि दीवानी वाद के लिए वाद का कारण और वाद कारण विवाद की विषय वस्तु होना चाहिए. क्योंकि पूर्व विमर्श से यह बात साबित हो चुका है कि वादी अपना हक साबित करने में असफल है, अतः यह बात वादीगण के विरुद्ध निर्धारित है.
Heard the learned council's opinion on behalf of the parties. They have placed the materials on record. During the course of arguments, it transpired that it was not in dispute that property was purchased by Dinanath Singh in the name of his wife, Srimati Lalpuri Devi, who had 5 children. One amongst them was Anil Kumar Singh, who died. During the lifetime of Lalpuri. The suit was filed by other 4 children against wife of Anil Kumar Singh and her children, seeking partition. A plea was raised in the written statement objecting to prayer of partial partition. Why has he gone? Mr. Sinha, are you going to some other court? Is it your case?
CMP is going.
I appreciate that. One little thing.
Yes.
An objection was raised with respect to partial partition.
Yes.
No issue was raised. The court has gone into the title. In a partition suit, there is no scope of going into title.
Unless the other side specifically reasons.
Yes, there is no title.
There's no.
The court has actually not decided.
Not decided. It has to go back, no?
It has to go back and we have to frame certain issues.
Yes.
2 issues can come up.
Yes.
Whether the suit was bad on account of partial partition.
Yes.
One thing.
Right. No.
Secondly, whether it is a joint family property or an ancestral property.
Right. Your Lordship, I heard that. No? Your Lordship, there is a distinction between the ancestral property flowing from a hodgepodge of joint in the family
Yes.
and mother's self-acquired property which are
Yes.
independent.
And whether it will be a self-acquired property for the mother because the
Yes.
property was purchased by the father in the name of.
Correct. Even if so, parents' properties and other joint family properties are
Yes.
different. So
And it
your-
is not the case that the property was purchased from hodgepodge of the
Correct, correct. So therefore, if this was, even if Lordship is absolutely right, that this issue has to be framed because there are
So you
exceptions.
just come up with both of you.
Huh.
You see, this is the situation. Let's you both of you behave like advocates now, not like litigants.
No.
You come up with issues which are required to be formulated, and we'll remind it back because it will need evidence. The evidence is required. Okay. So I'm just giving a short dictation, posting it tomorrow, and I think it's a case for remand.
Yes, on these additionally on these issues.
Additionally on this. You can go now. An objection was raised by the defendants with respect to partial partition. And numerous joint family properties were mentioned in the written statement. Numerous ancestral properties were mentioned in the written statement. However, the learned court entered into title dispute, entered into the title with respect to the suit property, in spite of the fact that in the written statement no dispute was raised with respect to the title of the property. Further, no issue was framed as to whether the suit was barred on account of partial partition. Post this case for further hearing tomorrow. Kal dikhayenge. Okay. Will be a short order, nothing much. We just go through.
We have to assist with the issues, proposed issues which may.
If you still say that it is not to be reminded, it is absolutely
No,
open.
I'm just clarifying words as to what are but.
Mr. Sharma, in a pending suit for partition filed prior to 2006, the daughter was not made part, but the judgment was pronounced after coming into force of 2006 Act. Does she become? Is she required to be a party in the proceedings?
That will depend upon whether she is a proportioner.
She is the daughter in the family.
If she is a proportioner, then she is the right.
Then she has to be added as a party. Because prior to 2006, she did not acquire the co-pastory right. Co-pastory right came in 2006, not prior to that. So, suit was filed prior to 2006. She, at that point of time, she did not have a co-pastory. But
that would be governed by the Hindu Succession Act
1956,
Section 14.
Limited right
She will have a right in the father's.
In the father's property. If there is a partition, she'll have a right in her father's property because that will be specifically assigned to her father.
Once she becomes a proportioner,
Yes.
then she will have a right in the father's property, which his father will get as a proportioner, as well as
right in the entire
her
property.
right also
As a co-partner, and so therefore, in a pending suit in the year 2006, she was to be made party.
She was a
Necessary party. She was to be added as a party.
Section 99 of the Code of Civil Procedure says normally a decree cannot be valid on the point of non-joinder or misjoinder. But if it is bad for a necessary party, then it can.
She actually filed an appeal saying that I was not made party.
She can file.
The property was standing in the name of her father. But the plaintiffs claim that it is an ancestral property. They sought partition.
Section 96, what is any person? If somebody
Yes.
is added by, there are old judgments.
That's right.
96.
No, appeal was maintainable, but the point is whether she was a necessity party.
It has to be remanded.
Has to be remanded. And it has to go to the trial court, not to the appellate court, because she'll file her written statement.
Yes. And there are judgments that if amendment has come during the pending proceeding, then it will apply.
Yes, we have
Yes,
dealt with so many judgments, but I'm not able to. In Vinita Sharma also this is there. Vinita Sharma is the judgment right on this
Yes.
point.
And my lord had also decided in one of my
Vijay
cases, Vijay Kumar Yadav. That is also
Vijay Kumar Yadav.
alias Ghosh.
Alias
Ghosh.
Ghosh. वो तो SLP में notice हो गया.
But
Oh, that lady used to come from Supreme Court.
yes.
Why? उसमें अभी
But
notice
that
नहीं
is
हुआ है
also
SLP
an
फाइल.
amendment on amendment. particularly about.
हाँ, तो हम तो चाह रहे हैं कि उसमें कुछ डिसाइड हो जाए।
नहीं, वो तो ऑलरेडी माइलॉर्ड ने किया।
नहीं, हमने किया है, लेकिन एसएलपी फाइल हुआ, आपको पता है, एसएलपी उसमें फाइल हुआ। हम लोग कुछ कुछ अपने जजमेंट्स का ट्रैक रखते हैं, नहीं तो फिर गलत जजमेंट हो जाएगा।
Judgments in my case, not I given a judgment. Not just it is Bola, it was also a landmark judgment on the widow in marriage.
Yes, I have बोला, मैं तो I remember that.
That was also.
आपको हराए थे कि जिताए थे?
I lost it.
You lost. So
But
you have not filed appeal.
it was, I'm not. But that was a landmark judgment in the bill. That it is a judgment on the daughter's side.
कुछ कुछ तो डिसाइड किया, लेकिन थोड़ा कंफ्यूजन रहता है जब तक चीजें बहुत क्लियरली। अच्छा, वो जो एंसेस्ट्रल प्रॉपर्टी 4th जनरेशन तक होना चाहिए ना, 4th जनरेशन कोपास्टरी प्रॉपर्टी, 4 जनरेशन तो होना ही चाहिए, उसके बिना तो वो कोपास्टरी प्रॉपर्टी नहीं बनेगा। हमको 3 था कि 4 था, थोड़ा कंफ्यूजन है। 4 है ना? हाँ
अनडिवाइडेड।
हाँ, अनडिवाइडेड। ये कहाँ मिलेगा? सक्सेशन एक्ट में है, मुल्ला में मिलेगा, सक्सेशन एक्ट में तो नहीं, उसमें नहीं।
अरुण मिश्रा साहब का जजमेंट है, जस्टिस अरुण मिश्रा, राकेश शर्मा बच्चे, that perhaps is the outstanding judgment.
हाँ, that is, I think that is the latest, ये दे देंगे। जजमेंट करना।
From notified list for judgment item 1, second appeal 556 of 2004.
This appeal is dismissed.
Wait, please.
From daily list item 3, WPL 2847 of 2024.
So in this case, only limited issue is left. With regard to.
Am I audible, madam? I may be joined.
Yes, yes, you are there.
With regard to interest on delayed payment of gratuity.
Yes.
I have given one judgment in the last date also, decided by his lordship. In this case, petitioner was retired on. Yes.
उनको दे दिया है, साइड को दे दिया।
हाँ, दे दिया। So in this case,
आज लगता है नहीं हो पाएगा, just 5 minutes आने।
2 मिनट का खाली हम सीक्वेंस दिखा देते हैं कि वो 30 दिन के अंदर नहीं आया है। बस जो काउंटर एफिडेविट फाइल किए हैं उसमें इवन ऑर्डर के 4 महीना के बाद वो जमा किए हैं। तो छोटे बोला ऑर्डर में बोला गया था कि 30 दिन के अंदर दीजिए, अगर 30 दिन में नहीं देते हैं तो 60 दिन के बाद आपको इंटरेस्ट लगेगा। एक बार खाली पेज नंबर 42 देखा जाएगा, पेज नंबर
42 of the
रीड
yes.
सेकंड पैराग्राफ में हमको ग्रेचुटी हमें मिल गया, उसके बाद लिखा है 30 दिनों के भीतर भुगतान नहीं किए जाने की स्थिति में अगले 7 दिनों के पश्चात प्रदान की राशि के वास्तविक भुगतान की
डिफॉल्ट है, डिफॉल्ट क्लॉज है।
और उसके बाद इन्होंने इनका काउंटरफेट का लास्ट पेज लिखा बस, पेज नंबर 50 चेक जमा किया 4 महीने के बाद की, इस ऑर्डर के 4 महीने का आफ्टर 4 मंथ दिस ऑर्डर, और रिटायरमेंट के 6 महीना तक इन्होंने ग्रेचुटी रिलीज नहीं किया। फॉर दैट रीजन आई एम पेइंग फॉर इंटरेस्ट।
कितना, किस पीरियड से किस पीरियड का?
ये हो गया 31/12/2015 से आज की डेट तक 17/8/2026।
नहीं, एक सेकंड, 31/12/2015 से
दिस इज द डेट ऑफ रिटायरमेंट।
दिस इज द डेट ऑफ रिटायरमेंट। और ये चेक तो लेबर कमिश्नर के यहाँ जमा कर दिए।
जमा
तो जमा कब किए? 2020 में किए हैं ना?
4 महीने के बाद, इस ऑर्डर के 4 महीने के बाद,
4 महीने के बाद किए हैं।
वो स्टैट्यूटरी
तो
पीरियड
यहाँ पे जो आपको ये इंटरेस्ट दिया गया है, ये आपको दिया गया है ऑन डिफॉल्ट।
इंटरेस्ट नहीं दिया गया, पेज में कैसे इंटरेस्ट नहीं दिया हमको।
30 दिन में नहीं जमा करने पर
इंटरेस्ट, तो 30 दिन में 4 महीने के बाद जमा किया। और 30 दिन स्टैट्यूटरी पीरियड जो सेक्शन 7 में बोलता है उधर कि आपका रिटायरमेंट 30 विदिन 30 डेज देना है, वहाँ भी 6 महीना नहीं वेट करने के बाद हम केस फाइल किए, वो इशू पे डिसाइड नहीं होता ऑन द पार्ट ऑफ ग्रांटी इंटरेस्ट, उसमें जो ऑनरशिप है डिसाइडेड दैट।
तो स्टैट्यूटरी इंटरेस्ट है, इसमें डिस्प्यूट रेज करने से थोड़ी होता है।
हाँ statutory interest।
31/12/2015 till
17.8.26 आज के दिन।
और इन्होंने जो पैसा दे दिया,
नहीं दिया अभी हम तो वो
ये तो पैसा जमा किए ना वहाँ
हाँ
पे।
जमा किए हैं, पर वो
चेक से जमा किए कि क्या किए हैं? कि ड्राफ्ट से जमा किए हैं?
चेक से जमा किए।
तो चेक से क्या मतलब है? चेक तो इट इज इन देयर अकाउंट ओनली।
हाँ चेक अभी तो कुछ हुआ नहीं, और वो भी चेक का वैलिडिटी भी खत्म हुआ, 3 मंथ भी था उसका। I have retired on 2015 euros. December 2015. They have submitted check on 2020 euros. After 5 years euros. And now as on date, 10 years has been passed euros after my time. More than 10 years.
Were you offered any amount earlier? Were you ever offered any amount?
No. I have only requested to grant me gratuity salary as per the cement wage board.
That's right.
But that issue has never been decided.
Yes, what do you say?
Your Ladyship, he was not accepting money on the ground that according to him the pay on which gratuity is to be computed is different than what was being offered.
From where do you say that he was not accepting the payment?
The order says so, Your Ladyship, and he has not
You
challenged
see,
that
if
order.
he was not accepting the payment, you should have deposited it in the court. You should have deposited it before the authority under the Payment of Gratuity Act. There is a provision to that effect.
Your Ladyship, the first and foremost thing is that there was an original order passed against him denying interest. That order stood merged in the appellate order. Now, Your Ladyship, kindly see the prayer. He has not even challenged that order. He filed the writ petition seeking for quashment of the original order only. And then he prays for consequent mandamus for payment. Please see the prayer portion.
This is it. Yes.
As because I am agreed with this
He is
order.
only concerned with this order. You see, the point is, under the provisions of Payment of Gratuity Act, the moment the case is filed, the employer is free to is supposed to deposit the admissible amount before the authority under the Payment of Gratuity Act. If he was not accepting, you should have deposited that amount. You have not deposited it, did you?
No.
If you have not deposited it, and whatever you are showing is only a check, the money is still with you. That is not a deposit. Check is not a deposit.
But he is not taking. The check was deposited there, submitted there in the court.
No. It is in the name of It is in the name of Labour Commissioner. How will he take it? It is not in his name. It is not in the name of the petitioner. It is in the name of Labour Commissioner. How will he take it? And that is not a deposit by any means. The money never came out of you. As per the section 7, you have to deposit it. In order to, you see, this is what is happening. In order to ensure that no interest runs
Yes.
The employer is depositing the amount before the authority under the payment of gratuity at whatever is admissible.
Yes.
Right?
Yes.
You have not done it.
It seems that for that purpose the check was deposited. Now your leadership
No,
says that this amount has
was-
not been.
No,
My
this
has to say
deposit,
that whether
this
we have
deposit
taken the
is,
amount or not.
this deposit is of the year 2020, that too by a check in the name of Deputy Labour Commissioner.
But then he had to take that money from there.
You see, the point is that this money, this is not a deposit. It is not a deposit. Not at all.
To revisit this leadership.
It is not a deposit. It cannot be said to be a deposit.
But in the meanwhile, question arises whether on face of the fact that Annexure 3 is not under challenge before this honorable court.
No, we will see that. It is a
Yes.
statutory interest. We are not being so technical about it. He has confined his relief to the point of interest only, and that is his prayer also.
No, his prayer is for caution of the whole thing.
No, not at all.
Yes.
No.
Please see the writ petition prayer.
We have seen it. You read it.
No, your leadership, I'll just read it.
Watching a part of the order.
Was part of the order because part of the order was in your favor, but then whatever was against you, that stood much in the with regard to interest. There is a clear order. Leadership Annexure 2 is the order against him at the original order. The original order said it starts at page. The original order starts at page 35. And at page 41 is the finding regarding interest. May I place it, your leadership? Page 41 bottom.
Yes, we are there only.
जहां तक ब्याज भुगतान का प्रश्न है तो इस संबंध में कानून स्पष्ट है जो इस प्रकार उद्धृत है। धारा 7(3) के अनुसार नियोजक को उपादान की राशि 30 दिनों के अंदर भुगतान करने की व्यवस्था है तथा 30 दिनों के पश्चात भुगतान राशि पर सरकार द्वारा अनुसूचित दर से साधारण ब्याज देय होगा। किंतु वादी के द्वारा यह विवाद उत्पन्न किया गया है कि वे सीमेंट वेज बोर्ड के तहत निर्धारित वेतन के अनुसार ही उपादान की राशि लेना चाहते हैं। एम्फेसिस है उसमें। ऐसी स्थिति में भुगतान में विलंब के लिए सिर्फ नियोजक को ही दोषी मानना न्याय संगत प्रतीत नहीं होता। अतः प्रतिवादी को निर्देश दिया जाता है कि so interest was not granted. Now he challenged, he preferred an appeal. That appellate order starts at page 43, and there the leadership will find it's a short order निर्णय portion at page 44. यद्यपि अपीलकर्ता द्वारा प्रस्तुत किए गए इकरारनामे की प्रति से प्रतीत होता है कि अधिग्रहण उनके यहाँ वेज बोर्ड के तहत कार्य कर पुष्टि नहीं होती है, then the provision of law, चूंकि इस अपीलवाद में यहाँ से चूंकि इस अपीलवाद में केवल अधिनियम के तहत ही निर्णय दिया जा सकता है एवं इसमें वेतन विसंगति के अभी निर्णय से संबंधित कोई प्रावधान नहीं, because he was insisting that my pay ought to be different and therefore gratuity ought to be different than what was being offered. अतः उपादान की गणना अपीलकर्ता को प्राप्त अंतिम वेतन के आधार पर ही की जा सकती है। Leadership, that was the issue. अंतिम वेतन और according to wage board scale which he was claiming. साथ ही अपीलकर्ता इसे तो स्वतंत्र की भविष्य में कभी सक्षम प्राधिकार द्वारा सीमेंट वेज बोर्ड के तहत वेतन प्राप्त किए जाने संबंध में कोई निर्णय प्राप्त होता है तो वे इस आधार पर शेष उपादान की राशि गणना कर प्राप्त करने हेतु प्राधिकार के समक्ष रख सकते हैं। अतः पूर्व में स्वयं को यथावत रखते हुए अपीलवाद को निष्पादित किया जाता है। So now the original order gets merged into this order. It's an appellate order.
He has not considered his grievance only, the appellate authority.
Pardon me?
The appellate authority has not considered his grievance only. This is what his grievance is.
Now please see his prayer before the writ court.
Yes, we are seeing.
In the writ application, the petition prays for issuance of appropriate writs order direction in the nature of certiorari. Now he claims for certiorari for quashing part of the order dated 25 to 2020. That means original order. Annexure 2 to this writ petition by the Deputy Labour Commissioner, by which now he describes what has happened by this order. And in the description, he says that appeal has also been dismissed. Right? It doesn't challenge that.
Thereafter, you kindly
There is
read.
no prayer for quashing of this. Then consequential is mandamus. A mandamus can be granted only upon setting aside of this order. Mandamus commanding father is going to pay and release a full amount of gratuity. So it is not only interest.
That's right.
Orally, my learned friend,
Because till
I'm
date
not
they have not
his
given
authority
you
to do
a
that.
single penny after 10 years of
साथ-
after more than
साथ-
10
साथ
years
कैसे
of
करेंगे my
retirement
learned friend?
payment. For that reason this prayer has been made.
No, I'm making submissions who am online. Please bear with me. Leadership, then the prayer is for mandamus commanding upon the respondent to pay and release the full amount of gratuity from the wages applicable to the cement wage. So that cement wage board wages is the moot issue which was required to be decided, which has been decided by both the courts. And in writ petition, he has carried forward his grievance. Now, if he is giving up that claim with regard to payment of gratuity as per the wage board, wage applicable to cement wage board, leadership, I have got no objection. But so far as claim for interest is concerned, that has specifically been denied, and he has not challenged that order.
आप इसमें आइए फाइल करिए.
ठीक.
You do it. I'll allow that. ठीक से प्रेड ठीक से बनाइएगा. ये टेक्निकलिटीज के कारण हम आपका डिस्कस नहीं कर सकते. WPL नंबर 2847 of 2024.
उस पर हमको कोई ऑब्जेक्शन नहीं हो, तो इनका आईए पर अमेंडमेंट हो जाए. I will not come in that. It was my duty to point out that this is a discrepancy relationship.
उसको कर देते.
With the sense of responsibility, I have said that issue may not take it otherwise.
No, I'm not taking it otherwise, but this is being too technical. But let us be technical and rectify the error.
But one thing, leadership, the impression that my learned friend has given to the court is that he is only claiming for interest. But
See,
that's not the correct position.
during the
The
course
petition
of
is as it is
argument,
the entire thing.
during the course of argument, many pleas are given up.
Very
Right?
much.
Parties agree for many things which may not strictly fall within the pleadings.
I bow down.
Isn't
the
it?
leadership may please record
So
this,
he
otherwise
is-
later
He is now confining his argument only to the payment of interest, which is a statutory
that.
interest.
That's what my request is. Leadership may observe that, because later we will say this point has not been considered.
That's right. Let him do the needful. He has to do the needful. Otherwise, there will be a technical flaw and it will go to the Supreme Court. So I don't want that.
Yes.
Let
There
him
are
do
two
the
things
needful.
now. There are two
You do
things.
the needful, right?
One can be done orally also, but it's better that he does that. His confinement only to interest,
Okay.
and second is challenge.
The learned counsel for the petitioner has submitted that the petitioner is aggrieved only by the fact. Are you sure about it?
Yes.
Only by the fact that even on the amount of gratuity which has been granted to the extent of rupees 2,22,342, the statutory interest has not been provided. As per the provision of section 7(3) of the Payment of Gratuity Act, the payment of gratuity is to be done within 30 days, failing which the employee is entitled for payment of statutory interest. He submits that the appellate authority has also not taken note of the fact that even on the admissible amount of rupees 2,22,342, neither the same was deposited before the controlling authority, nor any interest has been paid on the amount. The learned counsel has submitted that he does not want to contest so far as the claim of salary and consequent gratuity on the basis of cement wage board is concerned.
There's no claim for salary.
A claim for gratuity on the basis of cement wage board is concerned. The learned counsel for the respondent has raised an objection by saying that in terms of the prayer made, the petitioner is primarily claiming gratuity to the cement, gratuity on the basis of cement wage board with interest in terms of Rule 7 with Matter 3 of the Payment of Gratuity Act. And he has challenged only the order of the controlling authority that is the Deputy Labour Commissioner authority under the Gratuity Act. The appellate order has not been specifically challenged, though it has been mentioned that the appellate authority has affirmed the order of the original authority without assigning any reason with regard to interest and wages from the Cement Wages Board. Counsel further petitioner submits that the relief may not be happily worded, but in view of the aforesaid submissions, he prays for and is allowed some time to file an appropriate interlocutory application so that the relief as stated by the petitioner is duly reflected. कितना दिन चाहिए?
2 weeks.
Post on 1st of September in the supplementary process.